We'll now proceed with the rule 1-1, new trial or reconsideration. New trial or reconsideration are among those remedies that can be availed of by the accused at any time before a judgment of conviction becomes final. The court may, on motion of the accused, or at its own instance, but with the consent of the accused, grant a new trial or reconsideration. In other words, when can this be possible? At any time before a judgment of conviction becomes final. And if a motion, either for new trial or reconsideration, is filed by the accused, it shall be resolved within 10 days with or without the comment of the prosecutor. What does this mean? That while the accused may file a motion for new trial or reconsideration, the prosecution shall be given a period of time, which say 10 days, within 10 days from receipt of the motion within which to comment, and with or without the comment of the prosecutor, meaning to say after the lapse of the period given by the prosecutor to do, the court shall resolve the same within 10 days from that period. What are the grounds wherein a motion for new trial may be granted by the court? In Section 2, it provides, the court shall grant a new trial on any of the following grounds. First, errors of law or irregularities prejudicial to the substantial rights of the accused have been committed during trial. Okay? Errors of law or irregularities that may prejudice the right of the accused committed during trial. And second, which is the most common, on ground of new and material evidence has been discovered, which the accused could not with reasonable diligence have discovered and produced at the trial, and which, if introduced and admitted, would probably change the judgment. Now, take note that the newly discovered evidence presuppose that it would not include forgotten evidence. Okay? What the rules provides is that new and material, they cannot be discovered, could not have been discovered with reasonable diligence at that time or produced during trial. So, what shall you do as the counsel for the accused? You have to prove, okay, you have to prove that the evidence must have been discovered after the trial, that it could not have been previously discovered and produced at the trial even with the exercise of reasonable diligence. It is new and material. If introduced and admitted, it would probably change the judgment. So take note of the requisites for newly discovered evidence. So you have to comply with the 4 requisites before the court may allow or grant you new trial. Now, how about the reconsideration? The court shall grant reconsideration on grounds of errors of law or fact in the judgment, which requires no further proceedings. In other words, you are just asking the court to reconsider its findings, whether it may be facts or the law as stated in the judgment, because to just ask for reconsideration, maybe because there are errors on the factual issues as stated in the judgment or on the law applicable, then that would be proper for reconsideration. Now, do not be confused, because in new trial, there are also errors, but the errors we're talking to there, errors of law or irregularities prejudicial to the substantial rights of the accused committed during trial. But the reconsideration here is the errors of law or fact in the judgment. but not on the proceeding, because the proceeding that is proper for new trial, in reconsideration, errors of law or fact in the judgment. So how do you do it? The counsel for the accused, or the accused through his counsel, should file a motion for new trial or reconsideration in writing, and he shall state the grounds on which it is based. So if it is based on newly discovered evidence, he has to state as well the requisites so that it will be granted. So if it is a motion for reconsideration, then what are the grounds relied to by the accused in filing the motion? Now, if based on a newly discovered evidence, the motion must be supported by affidavits of witnesses by whom such evidence is expected to be given, or by duly authenticated copies of documents which are proposed to be introduced in evidence. Okay, so these are the things that the accused has to do in filing the motion for new trial or reconsideration. Now, what else? Notice of the motion for new trial or reconsideration shall be given to the prosecutor. In other words, you have to furnish a copy of the motion, the prosecutor, because they shall be given a period of time within which to comment on the motion for new trial or reconsideration. When a motion for new trial calls for resolution of any question of fact, the court may hear evidence thereon by affidavits or otherwise. What do we mean by this? That the court will just be content on considering, evaluating, assessing the affidavits as attached in the motion, or he may conduct a hearing which shall be summary in nature on the motion. When we say summary, during trial or during the hearing of that particular motion, they will just have to reiterate the contents of their affidavit, so it would be faster. That's why it's summary. Now, what would be the effect in case the court would grant the motion for new trial or reconsideration? Remember, there is already that judgment rendered by the court, but prior to its being final, you have their new trial or reconsideration. Now, let us say that the court grants the accused new trial or reconsideration. What would be its consequences? What would be its effects? The effects of granting a new trial or reconsideration are the following. When a new trial is granted on the ground of errors of law or irregularities committed during the trial, all the proceedings and evidence affected thereby shall be set aside and taken anew. In other words, it is as if that those evidences previously presented shall not be taken into consideration. It will be set aside. And with the new trial, as if you will be having another trial, new trial for that matter. So, if you are the counsel for the accused, since the law considers it that its previous evidence shall be set aside, if you want to still present them, you have to present them anew, in addition to your newly discovered evidence. The court may, in the interest of justice, allow the introduction of additional evidence. Okay, so as what I have mentioned earlier, since the previous evidence presented and offered has been set aside, if you want to make use of them still, you have to take them anew, let the accused identify, let the witnesses identify, and present it during trial, the new trial that is being conducted. When a new trial is granted on the ground of newly discovered evidence, the evidence already adduced shall stand. Okay, if you notice here, the grounds here is errors of law. But since your evidence has been set aside, that is my suggestion, to make use of those evidence because they had been set aside. But if your ground is newly discovered evidence, the evidence already adduced shall stand. It will not be set aside. It remains there. All you need to present is the newly discovered evidence and such other evidence as the court may, in the interest of justice, allow to be introduced and shall be taken and considered together with the evidence already in the record. Okay? So, I think that is self-explanatory. Under both circumstances, whether it is based on errors of law or newly discovered evidence, when the court grants new trial or reconsideration, the original judgment shall be set aside or vacated. Meaning to say, the court has to render a new judgment after the conduct of the new trial. What is the so-called napies rule? This is the remedy of the accused if in case his motion for new trial or reconsideration shall be denied. Because the previous slides that we have, it is the granting of the new trial or reconsideration. Now, how about if the court shall deny your motion for new trial or reconsideration? Now, in napies rule, though it is a civil case, not criminal, it provides that the period of appeal is not only within 15 days from notice of the judgment, but also within 15 days from notice of the final order appealed from. And from this napies rule, the court, in the case of Judith Yu versus Samson Tatad, it adopted the napies rule in criminal cases. So what is its significance? In the case of Samson, okay, Yu versus Samson Tatad, to standardize the appeal periods provided in the rules and to afford litigants fair opportunity to appeal their cases, the court deems it practical to allow a fresh period of 15 days within which to file a notice of appeal in the RTC counted from receipt of the order dismissing a motion for new trial or motion for reconsideration. What does this mean? That if you file a motion for new trial or reconsideration within the 15-day period and the same was denied by the court, because when you file it, it will not be resolved by the court on the very same day. It would also to eat time. Probably if you file your motion for new trial or reconsideration on the 10th day, do you think the court will be able to resolve your motion within the 5-day period left prior to the consummation of the 15-day period? It may not be possible. So what would be your remedy just in case your motion for new trial or reconsideration and it was resolved more than the 15th day? So in that case, the court actually gives the accused a fresh period of 15 days. Reckon from receipt of the order dismissing a motion for new trial or motion for reconsideration. You reckon it from this date. Receipt of the order dismissing a motion for new trial or reconsideration, you have a fresh period of 15 days within which to file your notice of appeal. Okay, so those are the salient features on Rule 121. So let's end the rule by saying our greatest weakness lies in giving up. The most certain way to succeed is always to try just one more time. Okay, so if it would be denied, your motion for new trial or reconsideration, do not lose hope. You still have your right to appeal. With that, thank you and good day.